The Seventh and Eighth Amendments are important because they address your rights in the legal system. Cherry, John, and I, Lauren, will be explaining just why they are so important and provide examples of legal situations that involved these two amendments.
The Seventh Amendment reads, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. This means that a jury of their peers can be present the moment a single person requires it or chooses so. An example of this is in the Gideon v. Wainwright case in 1963, where Gideon appealed for an attorney since he could not afford one. And the Supreme Court ruled that the right of trial by jury shall be preserved and no fact tried by a jury shall be otherwise re-examined in any court of law of the United States than according to the rules of the common law. So Gideon was given an attorney for him, since one should be appointed to him. In the past, the jury was somewhat controversial. Today, the jury is more fair since both the attorneys and the lawyers will be vetting the jurors.
The Eighth Amendment reads that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Bail is money that an accused person pays in order to get out of jail while awaiting trial. The government returns the money when that person appears in trial. It is confiscated if they fail to appear. This amendment ensures that bail and fines are reasonable. The definition of cruel and unusual punishment has evolved throughout the years as a result of legal challenges and cultural differences surrounding this amendment. For example, public whippings were common punishments around the time this amendment was introduced. However, in modern times, they would be considered cruel and unusual. Today, capital punishment is a controversial topic. Many Americans hold the opinion that capital punishment, otherwise known as the death penalty, should be considered a cruel and unusual punishment. In the case Furman versus Georgia, it was ruled that the death penalty is considered cruel and unusual if capital punishment was sentenced unfairly between identical crimes. By 1976, in the case of Gregg versus Georgia, states revised and passed laws to consider the death penalty a constitutional sentence. In 2005, it was ruled unconstitutional to subject anyone below the age of 18 to the death penalty. These court cases showed the evolution of laws surrounding this amendment.
Now that Cherry and John have explained the two amendments, let's go over the main points. We know that the Seventh Amendment translates to a jury that can be present the moment one person wants the trial to be in one of their peers, which is important because most trials nowadays have a fair jury chosen by the people the attorneys and lawyers vetted. As for the importance of the Eighth Amendment, it ensures that bail and fines are reasonable and eventually made people think about the real question: where does the line of cruel and unusual lie? Thank you guys for watching.